we are super happy to have Ekin Jeng, who is doing his doctorate in law at Oxford, and Ekin is researching private governance system, private legal systems, and we at Kleros we are supporting his doctorate with a partnership. So we are super happy to welcome him here, and so he can tell us a bit about his studies and about him. Hello, Ekin. Welcome to our call.
Hello, good to be here.
Well, welcome. I'm happy that we can be starting our collaboration. I mean, tell us a bit to our community about you. I mean, what is your research? How you got interested into the topic, so people get to know you a bit.
Yeah, absolutely. So my name is Ekin. I'm originally Turkish. The whole idea came out of a presentation I did at the DL News company retreat years ago. So I tested the idea there. DL News is where I work as editor-in-chief, by the way, sister organization of DeFi Llama, which tracks DeFi analytics, as those in the community will know. And essentially, it's the research title is Decentralized Finance as Private Order, and it goes to the ideas Federico has masterfully covered. And I'm so glad I don't have my slides up, because I was going to cover the same basics as he did, including this very book that I have on my desk. Excellent book. Right, so the idea is pretty much like the stock exchange example Federico gave, and indeed others. That tight-knit communities can generate social norms, maintain social norms, and they can maintain a sense of order without the need for state courts, state law, or in the scholarship we say state legal systems. But that doesn't mean that they are necessarily antagonistic to the state. One definition in the scholarship we see is that the private orders are usually in the shadow of the state, right? So sometimes states come into play, sometimes there are conflicts, sometimes private orders turn to states for help. So that's the general framework. And as to how that applies to DeFi, if you've been in crypto, blockchain, you'll be familiar with the question, what maintains order in DeFi, and or maybe you'll be more familiar with the one of the answers to it, which is code is law. And then the second answer, which Federico you also mentioned, that without the state there shall be chaos, right? There's this idea, and we see in the press, mainstream press, they call crypto DeFi, they call it the Wild West. And I often like to give example and I move on to say, well, it's not necessarily the Wild West, but that book you showed, I think, is maybe an answer to, well, maybe Wild West is not really wild after all, right? It has its own internal logic, which is true. We see it like the book you showed, we see it with the pirate communities and also with like prison gangs. David Scarbeck has this interesting book on the order of the underworld. Mafia, all sorts of organizations can have their internal logic. And that seems to be very common with merchant communities, fishing communities, and traders, and indeed finance historically. There seems to be something about money being at stake, perhaps, that like ties people together, and perhaps some sort of expertise. Anyways, without getting to in details here, I'll just mention that usually the question what maintains order in DeFi, in scholarship and in the industry as well, and in mainstream media, we see two answers, right? One is code is law, which I call techno-determinist idea, because it assumes that technology is what maintains order. It's all smart contracts, it's mathematical logic algorithms, and completely ignoring the human discretion that exists everywhere, from the governance to snapshot, and the informal mechanisms. Think about like SEAL 911, this group that intervenes every time there's a hack. Then we've got like oracles. I mean, even Kleros is one example, right? That people coming together to debate. There's a lot of human discussion. There's a lot of human involvement. It's not all automated. So the idea that code is law is unsatisfactory for that reason. And then the other idea, of course, what I call legal centralism, and that's the idea that the state law is the only source of law, only source of order. That's also wrong, because we know historically that we've lived in legally pluralist societies. There have been different sources of order. The book by David Friedman and others is an example of that. Lots of examples here. I mean, Jewish law is the most common one, but like medieval Iceland is one thing you mentioned. Maybe that's an old example, but in the scholarship today, the most famous example, and that's one that still lives on today, is the Jewish diamond traders in New York. And the question, of course, like, why do they even have that? Why don't they resort to a state court system? And the scholarship says that because diamonds are so small, high value, and they're specialist objects, they are difficult to just escalate to state court. So the communities found historically that the state courts were ill-suited for resolving their disputes efficiently. So instead they developed this, private arbitration and reputation-based enforcement system. Similarly, whaling crews in the 18th, 19th centuries, especially in New England, being so far away, from any state authority, they developed these ship's articles because they needed a way to settle their disputes. Clear self-enforcing agreements. And Japan is an interesting one. The Dojima Rice Exchange in the 18th century, Japan, in Osaka, they also relied on self-regulation because futures trading was this novel financial innovation that state institutions had neither the expertise nor the infrastructure to govern efficiently. So then the question arises, why in crypto we see such little reliance on state law, right? I have some, tentative answers. Happy to debate with anyone. One is probably the classic, the technology law gap. It's the same thing with like sharing economy, sharing platform, Uber, that sort of stuff. But that's too broad. Then there's, the technical affordances, because the way blockchain works, the smart contracts, and you deploy it anonymously, you don't have to register anywhere. That kind of allows that system to happen. Then third, you could say there are normative aspirations, and I think that is interesting. So there are like ideological underpinnings that DeFi separation from the state is actively maintained by a strong like idealistic commitments within the community, where many participants reject like traditional financial regulation, viewing it as like restrictive, opaque, and historically it didn't serve its purposes, and so on. So these are the reasons why that might be the case. So the interesting, Federico, you mentioned like, can we build like private order system? I think the question I want to tackle, I've been tackling, is, well, have we built those systems? I think evidently we kind of have. I think your question is interesting because that goes into whether like these systems can survive long term, whether we can still maintain them. That's something that I also, tackle. But the first task is to offer a third alternative to this code is law, techno-determinist idea, versus legal centralism. The source of order is only the state. The third alternative, historically, we know that private orders have existed, and we might be seeing one emerging just in front of our eyes. I'll stop here in case you've had any questions, because I know that we want to do it a bit more interview style, but I got more to say, but maybe.
I honestly, it was so clear. I didn't feel like interrupting. I would say like how? So what is the methodology you're going to use to answer to this question?
So I'm using. This is in socio-legal studies, which is, the empirical social science study of the law. And it's one corner of the legal scholarship that's very receptive to this idea that law and order can come from non-state sources. So I'm using social science methods, qualitative methods. It's interviews, ethnography, so ethnography being digital ethnography. I'll be meeting some of the jurors of Kleros. So that's one example. I'm hanging out in our governance forums on Discord. I'm on crypto Twitter all the time. I mean, working as an editor-in-chief as well at DLS, covering DeFi, I'm exposed to these ideas all the time. So methodologically, I'm very fortunate that I'm in a very I'm in an environment that encourages like innovative methods and not so much like strict box ticking exercise. So as long as I find answers to the questions I ask, and as long as they are reliable answers, I go with that. But broadly, it's interviews, ethnography, and the cool thing about our community, of course, the broad crypto communities, it's all transparent. There's an emphasis on like public discussions. There's a lot of reflection on things like Cotter's law, for instance, and on top of this, there's also a lot of scholarship. And so one difference, my research, I guess, one way it differs from other scholarship is that it's quite empirical in the sense it's focused on what exists today rather than what blockchains can achieve. Because if you look at scholarship, there's a lot of talk on like the blockchain revolution and what smart contracts can do and can achieve. But we already have examples of for instance DeFi at 100, I don't know what it is today, $120 billion total value locked across all protocols. It's been working somehow, orderly with little reliance on the state. So it's right there. We have mechanisms like Kleros. We have other informal mechanisms. So Kleros, I mean, we can also talk about Kleros more specifically. As I mentioned to you before, it's interesting because it's a formalized. There's formalized language around it, right? Like the tuna courts of Japan, I think comes to mind because the tuna industry in Japan developed this method of resolving their conflicts outside the state, and they use the language they borrow from state court systems. And there's something I think comforting about that because people are familiar, with those words, familiar with the ways of doing justice with the state. But of course, we are doing it without the state because the state doesn't have monopoly on justice. So yeah, that's a long answer.
I mean, one of the things that I think that we did well was call it, as people could understand, but jurors, when we speak with people who come from the arbitration world, they are a bit, angry that we call this arbitration because they said, oh, this is not arbitration because it doesn't work like arbitration. Maybe in the future. So arbitration is in a broad sense, you could call it arbitration, but and I think that one of the reasons of the success of Kleros is that it kind of was addressing how people saw these systems working. And I mean, even if they were not lawyers, but everyone knows a bit how legal systems work. And so the fact that we use the same vocabulary made it like close to people who, and you see this on the memes, about trials, and it's very fun. And yeah, people use like your honor to address, the jurors, and so it's fun.
Yeah.
Yeah. What?
Yeah. So good points. Yeah. So whether it's private arbitration or not, of course, is one debate. And as I said before, you'll remember maybe there's a broad definition, narrow definition.
Yeah.
And if it seems to be doing something, doesn't matter what the definition is, then there are debates whether those definitions matter. But yes, I mean, that's an interesting one. And bear in mind though, so interesting thing about Kleros, of course, that it's and correct me if I'm wrong, it's ex post dispute resolution, right? So people, when they think about private orders, they immediately think about this, right? The conflict resolution. And it's a big part of it, of course. But it's not the only part. There's a whole background to this in preventing conflicts from arising. So the ex-ante conflict prevention, right? Like before we even get to the dispute settlement phase, like how do we arise problems from, how do we prevent problems from arising in the first place? And one example of that is in the community, I mean, some of you will be familiar, the MEV case, right? Maximal extractable value. So interestingly, I mean, for those who don't know, I don't want to get into too much in detail, but because Ethereum public blockchain, you know, there's this waiting room called the mempool. That's where like your transactions wait for like 12 seconds before they are processed by a block validator, right? And because this information is there, people have found ways to exploit it. So like sandwich attacks, front running, you know, people submitting transactions just before your, you know, token swap order, for instance. And there was some estimate in 2024 that it could cost up to $1 billion. And I remember there was a website where people tracked MEV, you know, the value lost to MEV, but it's not there anymore. And interestingly, the community decided, you know, that this is exploitative. There was a broad agreement within the Ethereum community, but I mean also Solana, other EVM chains, that this is exploitative. People are being taken advantage of. You know, bad forms of MME, of course, there are also good forms. And people found solutions. So now we have like private relays, like flash bots, for instance, and now transactions go through them. It's actually 80% of all transactions. I just looked up on Dune, and probably more for like percentage of trading volume. So the MEV problem has been kind of solved, and that's an example of ex-ante, you know. And simultaneously, and we published about it on the Alnus very recently, there's a court case in the US that's where these two brothers who were involved in, you know, MEV now are being accused of wire frauds. So like, you know, fraud with the internet, essentially. The Americans call it wire fraud. So obviously that's a case that I think the community has pretty much solved. I mean, there are still other solutions in place, but so now we see the court stepping in. So that's interesting, right? So I'm not saying that DeFi is completely immune to the state systems. No, private order like those that you mentioned, for instance, there are more examples, right? There are money markets in Kabul. There's an interesting paper on that by Nafai Chaudhry. One of my assessors, Florian Girsel, has this book on the fissures of Marseille. All of those communities, private orders, they still deal with the state somehow. Sometimes the state steps in. Sometimes these communities, you know, ask for help from the state as last resort. So we know, for instance, like Zach XBT, you know, he does amazing work. And then sometimes he shares his findings with, say, the French police, for instance. That was the case, I think, last year or the year before. And then the French police intervene and arrest this, you know, crypto criminal. So that's like an example where, you know, the states and private orders can work together as they come into clash sometimes as well. And for Kleros, the interesting thing, of course, it's, I mean, you mentioned the token dispute resolution, but it also exports decisions, you know, justice to state court systems, right? Like the state court systems also recognize, just as they do with private arbitration. Look, there are cases of like Mexico, Colombia, maybe you can talk about them. So that's also interesting how now the community has not only developed these mechanisms to resolve its own disputes, but also expanded to other areas that are not only related to, you know, DeFi, and manages to export externally. And that we see that with other private orders as well, that they can cooperate with state systems. So the point I want to make here is that it's not a, you know, antagonistic clash, but there are a lot of overlaps.
I speak to lots of you know, people from arbitration regulators. You know, we have discussed with the UNCITRAL. We have helped make rules of arbitration. We advise the ICC in France. So, and one of the things I sometimes tell them, so it's something like follows. So we will help you a lot resolve the disputes happening in this world of digital transactions, DeFi, metaverse, if you want to call it that way. So because we are like native from this other world, and you will still, you will still have a dispute, happening in the real, mid world, and that's still going to be there. But I mean, the digital world has become a new jurisdiction, and you need like a native system for resolving that. And this is kind of a private ordering coming from Kleros as a legal order. So this is what I sometimes discuss with regulators, and I don't want to. I mean, we could stay for hours discussing. Just one last question for now, and we will have you back in a few months, so you can tell us a bit about the progress that you're doing. Tell us, I mean, from a practical perspective. So, what are the steps in your doctorate? I mean, you're starting, and yeah, what does it look like for your roadmap? Towards the dissertation.
Yeah, so academia moves very slow. I mean, I had this book idea already separately, but if you want to be taken seriously by scholarship, the scholarly communities, and if you want to publish with a university publisher, then you need to have your output supervised and have its academic quality, confirmed by an institution. So and then that world moves very slowly, unlike DeFi. So I'm collecting data for 1 year. That's what I've been asked. And come October, I will start, submitting chapters that will then turn into a book. And I will be assessed on it again by 2 assessors. And then a final assessment. Then there will be external assessors who are experts on private orders and also blockchain law and that sort of stuff. And then hopefully that will turn into a book. And the practical implication of this research is also this. So you talked about Ed Stringham's book on private governance, which covers financial institutions and how they emerged as private clouds. Historically, states have co-opted the rules that were organically generated by communities. So the financial regulation in the US, for instance, has absorbed some of those rules, like the membership rules in the New York Stock Exchange, for instance. They've been transported to financial regulation. So hopefully one takeaway will be, if the states recognize that, the blockchain community have built a private order, maybe then the state, instead of superimposing regulation, it will, understands its internal logic and have those regulations, if necessary, transported into state regulation. So hopefully that's one practical takeaway. And yeah, so 1 year of data collection, and I'll be doing like background writing and all that meanwhile, but the biggest chunk of writing is starting September. So that's how it goes. I'd like to do it as soon as possible, as I told them, because unlike other type of research that other people may be doing, DeFi moves at an incredible speed. Blockchains, things change very fast. But so we obviously had like a massive liquidation recently. We had the balancer hack, so all those things will be going into my research now. How the community responded, and same with the Kleros cases that I'll be seeing as a juror myself, and look forward to chatting with those in the community as well. So yeah, I'll leave it there, but happy to answer any question. If somebody wants to reach out privately as well, please do so.
Yeah, just one last thing. I mean, how can the community help you? I mean, people from the community watch this stream, and then how can they reach to you? Is there anything specific you need from the community to help you with your research? I mean, yeah.
Reach out to me privately and just throw your ideas at me, based on what we discuss, and I'll follow up with questions. It's very, we can also anonymize you if you don't, want to reveal your name or whatever. That's completely fine. It's very informal. I mean, I'm just saying it so that you don't feel pressure to turn it into a formal presentation. And I'd love to include interesting, insightful contributions into this book, because the contribution will be as strong as the community the book is trying to cover, not just the Kleros community, but also the wider blockchain community. But also the critics, as you said, some people will say the Kleros is not private arbitration, so their voices also need to be included and analyzed as well. So anyone remotely interested and have some thoughts on anything like code as law, private orders, and dispute resolution, or alternative resolution mechanisms, those things, just reach out, and I think whatever your contribution will be, like I'll just trust me to steer the conversation and we'll make it work. There's no process, there's no formality, but I'll assume that I have your consent if you reach out, because Oxford makes me say share with those that I collect data from, that I understand they are giving their consent and they can withdraw anytime.
Ekin, thank you very much for coming, and we will have you again in a few months, so we can learn a bit more about your program. Okay.
Wonderful. Thanks so much for having me.
Thank you. Bye bye.